Page 178 of the Mueller report has been redacted, citing harm to ongoing matter. Large sections of page 179 have been redacted, citing harm to ongoing matter and personal privacy. Brief sections of page 180 have been redacted, citing harm to ongoing matter and personal privacy. 2. Potential Section 1030 violation by See United States v. Willis, explaining that the 1986 amendments to Section 1030 reflect Congress's desire to reach intentional acts of unauthorized access rather than mistaken, inadvertent, or careless ones. In addition, the computer likely qualifies as a protected one under the statute, which reaches effectively all computers with Internet access. United States v. Nozzle. Applying the principles of federal prosecution, however, the office determined that prosecution of this potential violation was not warranted. Those principles instruct prosecutors to consider, among other things, the nature and seriousness of the offense, the person's culpability in connection with the offense, and the probable sentence to be imposed if the prosecution is successful. C. Russian government outreach and contacts. As explained in Section 4 above, the office's investigation uncovered evidence of numerous links between Trump campaign officials and individuals having or claiming to have ties to the Russian government. The office evaluated the contacts under several sets of federal laws, including conspiracy laws and statutes governing foreign agents who operate in the United States. After considering the available evidence, the office did not pursue charges under these statutes against any of the individuals discussed in Section 4 above, with the exception of FARA charges against Paul Manafort and Richard Gates based on their activities on behalf of Ukraine. One of the interactions between the Trump campaign and Russian-affiliated individuals, the June 9, 2016 meeting between high-ranking campaign officials and Russians promising derogatory information on Hillary Clinton, implicates an additional body of law, campaign finance statutes. Schemes involving the solicitation or receipt of assistance from foreign sources raise difficult statutory and constitutional questions. As explained below, the office evaluated those questions in connection with the June 9 meeting. The office ultimately concluded that even if the principal legal questions were resolved favorably to the government, a prosecution would encounter difficulties proving that campaign officials or individuals connected to the campaign willingly violated the law. Finally, although the evidence of contacts between campaign officials and Russian-affiliated individuals may not have been sufficient to establish or sustain criminal charges, several U.S. persons connected to the campaign made false statements about those contacts and took other steps to obstruct the office's investigation and those of Congress. This office has therefore charged some of those individuals with making false statements and obstructing justice. 1. Potential coordination, conspiracy, and collusion. As an initial matter, this office evaluated potentially criminal conduct that involved the collective action of multiple individuals not under the rubric of collusion, but through the lens of conspiracy law. In doing so, the office recognized that the word collude appears in the Acting Attorney General's August 2, 2017 memorandum. It has frequently been invoked in public reporting, and it is sometimes referenced in antitrust law. See Brook Group v. Brown and Williamson Tobacco Corporation. But collusion is not a specific offense to or theory of liability found in the U.S. Code, nor is it a term of art in federal criminal law. To the contrary, even as defined in legal dictionaries, collusion is largely synonymous with conspiracy, as that crime is set forth in the General Federal Conspiracy Statute. See Black's Law Dictionary 321. Collusion is an agreement to defraud another or to do or obtain something forbidden by law. Alexander Burrell, A Law Dictionary and Glossary. An agreement between two or more persons to defraud another by the forms of law, or to employ such forms as means of accomplishing some unlawful object. Bovier's Law Dictionary.